The purpose of this video is to discuss the legal considerations of illustrated erotica featuring children or childlike participants, which I will henceforth describe using the term lolicon. The term lolicon is shorthand for Lolita complex, and in Japan refers to the adults attracted to young girls. However, in its English usage, lolicon refers to manga and anime illustrations themselves, rather than the person viewing them, and it is how I'm using the term. Furthermore, while lolicon refers explicitly to females, all of my arguments apply equally to lolicon and shotacon being the male equivalent term. Please keep all comments relevant to legality considerations. If you wish to address general interest in lolicon, or just wish to flame deviant perverts in general, please do so in my lolicon apologetics video, Understanding Lolicon. Let me first start this with the formal definition of child pornography according to US law. This is found in United States Code, Title 18, Chapter 110, subsection 2256, Bullet 8. This is a little cumbersome, so I'll read the entire definition here. 8. Child pornography means any visual depiction, including any photograph, film, video, picture, or computer-generated image or picture, whether made or produced by electronic, mechanical, or other means, of sexually explicit conduct where a. The production of such visual depiction involves the use of a minor engaging in sexually explicit conduct. B. The visual depiction is a digital image, or computer-generated image that is or is indistinguishable from that of a minor engaging in sexually explicit conduct, or C. Such visual depiction has been created, adapted, or modified to appear that of an identifiable minor is engaging in sexually explicit conduct. So under this definition, what can be considered child pornography is the actual photography and filming of children involved in sexual activity, near photorealistic computer CGI, and creative splicing to create realistic appearances of children engaged in sexual activity. I say near photorealistic because real photographs could conceivably be retrofitted with some filter that gives the appearance of a drawing or rendering, such as seen in the movie A Scanner Darkly, which would still be unacceptable. This chapter has a further definition, going into greater detail on the term indistinguishable. Bullet 11 states, 11. The term indistinguishable, used with respect to a depiction, means virtually indistinguishable in that the depiction is such that an ordinary person viewing the depiction would conclude that the depiction is of an actual minor engaged in sexually explicit conduct. This definition does not apply to depictions that are drawings, cartoons, sculptures, or paintings depicting minors or adults. Put more plainly, this clause states that drawings, cartoons, and paintings cannot be considered indistinguishable from a minor engaging in sexual activity. Ergo, lolicon cannot be governed by child pornography law, as every medium in which it exists is exempt from the definition of child pornography. This basic definition does have a third interesting prong regarding identifiable minors. By my reckoning, this is a fair provision, as sexually suggested fiction correlating to real persons could be construed as a threat, just as much as fictitious violence featuring real persons is considered a threat. I'm not sure how this would apply to deceased minors, as they cannot be threatened, but I assume it's just a loophole inadvertently increasing the scope of the law, but it's one that I'm not in a huge rush to close. What lolicon is subject to, however, is obscenity law. Many people, myself included, feel that obscenity law in and of itself is an absurd abridgment of the First Amendment and ought to be abolished, but it's still important to know what it is. The legal terminology is somewhat obtuse, so I'll use the layman's paraphrase of obscenity law, the Miller test. The Miller test was established in the court case Miller v. California. In this case, the appellant's conviction was specifically based on his conduct causing 5 unsolicited advertising brochures to be sent through the mail in an envelope addressed to a restaurant in Newport Beach, California. The envelope was opened by the manager of the restaurant and his mother. They had not requested the brochures and complained to the police. At this point, I'm totally sympathetic to the plaintiff. I do not believe that sexually explicit media should be displayed in public or where it would be difficult to avoid, nor should anyone be able to wantonly promote sexual material towards persons who are not interested. However, in a somewhat baffling miscarriage of justice, the case ruled not on whether or not this material should be in view of those who did not solicit it, but whether or not the material could be distributed at all. The true irony of this is I agree with their criteria, just not the scope of the application. In any event, here's the so-called Miller test. A work is considered obscene only if all the three following conditions are satisfied. Whether the average person applying contemporary community standards would find the work taken as a whole appeals to the prurient interests. Whether the work describes in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law. Whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. These standards would be fine and dandy if they governed what you could put on billboards in your neighborhood, but there's no reason whatsoever why they should be applicable to private display and viewing. Furthermore, when put in the context of private distribution, this definition has some fundamental flaws. First, it does not clearly define community well, nor does it give instructions on how to define community. Second, the mere premise of having a law subject to variable interpretation is absurd. National law should not vary by geographic location, as long as the location in question is still within national borders. So in the problem of definition, I would hope that if I were ever subject to obscenity hearings, that I may have my community defined as the collection of former frat boys from the university I attended. What is considered patently offensive can have a huge amount of leeway. I don't believe that any of my frat buddies were seriously offended by the electric retard. Rather, we were all terribly amused after a long night of LAN gaming while viewing a website that was allegedly banned in Germany. So what is the grand conclusion of this? In the United States, Lolicon media is fundamentally legal unless an overzealous district attorney decides to attack a private citizen with a gang of 12 neocons in order to ban a specific publication on a case-by-case basis. So even with all my hate of the Miller test, it does have one redeeming factor, namely the third clause. If a work is sufficiently good, it is protected from obscenity litigation. Now, what actually qualifies as serious literary or artistic value is again arbitrary, but I think one can examine it through the filter of how confident is a litigator that he would be able to convince a jury that this lacks value, and how distressed would the average person be to see this. For example, many visual novels and manga have reasonable literary value, and unless they're extremely offensive, they would likely not be worth pursuing. Also, standalone artwork of particularly high quality, such as illustrations by Satoshi Urushihara, who frequently features Shotokan content, might also likely be considered of serious artistic value, or at least serious enough that a litigator would not want to risk losing a case. With the case of Chris Hadley, which I'll not go into great detail here, we have an example of some Lolicon manga that was considered to be obscene. One of the 7 works in his collection which he was indicted for was Jido Puruno by Maki Fushigi, and here are a few images from that volume which I was able to track down through web searching. I'm including 2 pages, neither of which is explicitly sexual in and of itself, but are still quite disturbing when taken in the context that they are a precursor to sexual misconduct. So what can we conclude from this example? First, there's little reason to assume that the victim is not a child. Secondly, the victim is shown to be subject to violence and is in clear distress. So while out of principle I don't agree with anything being banned, I can empathize with the people who would want to ban this book. Now let's consider a more borderline case, the visual novel Cat-Girl Alliance, which I'm confident is fully legal because it is published in the US by JAST. Here I'm just showing a few lines exchanged between 2 characters before sex. This is not a complete conversation, nor does it show any actual sex, but it gives the context of the sexual interaction. Here we see a very childish figure. However, despite looking childish, her intelligence seems to be greater than that of a child, and the commencing sexual activity is clearly consensual. Now, I'm sure there are places that one could put this to the Miller test and it would be deemed obscene. However, given that its potential for offense is comparatively low, it's very unlikely that any attorney would attempt to pursue it for obscenity violation. One of the frequent arguments that arises on this subject is whether or not images affect behavior, and what is the result of that effect. I've read arguments and studies that come to both conclusions when applied generally to any sexual assault, so I'm not about to make any claim one way or the other. However, whether lolicon media provides a cathartic effect, hyperstimulates potential perpetrators, or has no effect at all, I find the argument moot because I support freedom of expression above all else. Extrapolating the worst-case scenarios, I prefer a small number of people suffer at the hands of criminals than the entire society get nickel and dimed into a 1984-styled thought crime system. Another of the frequent anti-lolicon complaints is that erotic imagery featuring children could be used to groom children into submitting to sexual acts. While I do agree that children are probably more likely to be influenced by illustrated erotica than live action, I think it's absurd to suppose that lolicon media would be significantly more effective. I really doubt that a groomable child would stop to question the validity of any illustrated pornography, barring perhaps the extreme situations like MILF hentai, and I would hate to have the government dictating how realistic eroticist illustrations must be and what its contents may or may not include. Furthermore, the same train of thought also concerns whether or not youthful appearing adults can participate in live-action pornography. I would hate to live in a society where the government was able to dictate whether or not my body was suitable for viewing.